my preference is to say, like, this is the end of the formal press conference.
Except that, okay, right.
Yeah.
Except then the person who's stuck on the podium is like, oh, I guess we're done. Okay, bye.
Yeah.
And they just kind of walk off. We have to quickly fade to black, and it's just an awkward end.
Yeah.
One time they kind of transitioned it from the formal press conference and then added, like, they announced at the beginning that there was going to be a press conference and then a backgrounder, and then at the
That's
end
what
of
I
the
announced
day,
at the beginning.
yeah,
But I
and
give a
then
2-minute warning.
But also that announcement doesn't go to the folks at home, right? It doesn't go to broadcast. So anyone watching the stream is
at the
unaware.
2-minute warning, if I give it at the 2-minute warning, I will announce that.
But the 2-minute warning doesn't go to air, right? So the folks watching the
Because I
stream.
speak it from that mic, though.
I know, but it doesn't go to broadcast. It doesn't go off stream.
It goes on. I think that mic goes through Porter's call, though, because I have them open up the line, so
That's
I
right.
speak on
All
it.
I'm saying
Then
is,
our reporters hear it.
right. All I'm suggesting to the viewers who are watching the stream of this, the live stream,
Yeah.
don't hear the 2-minute warning, so they don't know that there's going to be questions after the questions. So when someone says, okay, this is the end of the press conference, now we're going to have more questions, and then the stream ends, everybody goes, hey, where are the other questions? Maybe I want to hear those too.
I mean, that's up to the reporters, though. Then they need a RSVP from the backgrounder, because that's something we make very clear. So if they're just watching, if people are just wanting to watch the live stream, but they want to be part of the backgrounder, then they really need to have RSVP.
Because in theory, there's like people all over the agency, all over the country or world watching the stream, right? But they're not necessarily press.
Yeah, and they don't need to be, but they don't need to be part of the backgrounder then. And if they would like to be, then that's something else.
Right.
That's not my call to make. I only need them. Backgrounders are for the reporters, so that they're briefed on the case.
Okay. All right. Okay.
Okay.
Cool.
Great.
All right. Thank you. I can't be a cog in anybody's wheel.
No, all good. These are good things to think through.
Seems to make sense to make it as smooth as possible to present everybody in the best light possible.
Absolutely. That's what we want.
Do you have another
Cool. I apologize for that wait.
Hey, no problem there. How's it going?
All right. So, wanted to just quick walk through our order of speakers. So, don't worry about doing the formal introduction. I will go up to the podium, or Christina will go up to the podium to give a 2-minute warning. At that point, I will message you to open up the. I'm just bringing it over for a second, please. I will bring it down. So I will go up, give a 2-minute warning, go through the order of speakers with everyone, and then at that point, I'll message you before I do that so we can open up the line, because I do want anyone who's calling in to hear that portion.
Okay.
If that makes sense, but don't worry about.
Yeah. So I won't give any kind of. Yep, I won't do any kind of introduction. Just let me know whenever you're ready to be joined into the main conference room.
Okay.
Just because right now I have us in like a separate room that where we're speaking in private.
Okay, but like
okay.
The person at the podium should go back to where the other person leaves from.
There are going to be 4 speakers today.
That makes sense.
So
okay.
After the last one, Assistant Attorney General Jeff Clark will be giving the last remarks, and then after him, that's when we'll open it up to a Q&A.
So like, I think Christian.
All right, and go ahead.
A fallback position for the DAG, so he's always in the shot.
Usually Jeffrey,
always
the
in the
DAG
shot?
will speak and be like, all right, and I believe now we have like a question and answer portion. At that point, you are good to come in
stand in front of this
and
person,
give the kind of the
especially for
instructions for how to enter the queue.
do COVID stuff.
So we can start working
I'm
on
at the bottom
that.
of the totem pole, so.
And then I'll just be messaging you throughout during the Q&A about who I want to be asking the next question.
Can you wait,
So we'll just
Melissa,
work out
come back?
that way. And then
Can you
after
stand in
a
front of?
asks a question, we ask that you just mute their line immediately afterwards. We just don't want them to have like an internal question. So as soon as they ask one question, we mute the line.
The DOJ flag.
And if you
Okay.
can make that announcement when you give the directions for how to enter the queue, that would be great. Just saying, please limit yourself to one question. State your name.
Okay. Okay, no problem. So yeah, I will just make sure to include the language to limit yourself to one question. After they give their question, I'll keep them muted. I won't kick them out of the podium just quite yet, just in case they need, like, the speaker asks for a clarification or anything.
Yeah.
But they'll still be muted, though. So once they ask their question, they'll be muted.
Great, thank you. And then
Yeah, no problem.
also for your awareness, there is a backgrounder immediately after this. So at one point, I will hop on and I will say this ends like the formal portion of the press conference. Please stay on for
Okay.
the backgrounder to follow up. So don't clear anyone out of the queue, because then we will have someone else
Okay, I'll just like confirm with you prior, just to, like once the background, like the second portion is done, that like that call has concluded.
Great. I will. Yeah,
All right.
and we'll be in contact throughout.
Yeah, absolutely. I have that View Q&A chat tool up, so we can just message through there.
Great. All right. If there aren't any
All
further
right.
questions, I think we're good.
9 p.m.
Yep, I'm all good on my end. If you're good on your end, I can just keep myself on mute, and then just let me know when you're ready to be joined into the main conference room.
All right, and actually, one sec. I'm gonna quick check the podium mic. Do you mind just staying on for one more second?
Yeah, absolutely.
All right, great. Thank you.
Because for like a split second, I was like, I don't know what he's talking.
Testing 1, 2, 3. Testing.
Yep, you're coming in. I could hear you coming in nice.
That would be
clear.
for Darrett. In the room. All right, thank you so much.
Yeah, no problem.
Can I talk at the podium and you bring the podium mic? Everything else is fine. The guy talking over the thing, everything, those levels are good, but the podium is good. Okay. Hey, can you do me a favor, Barry? I'm gonna talk at the podium. Tell me he's gonna raise the level because it's a little level. Let me know how it goes. This is the podium check, mic check. 1, 2, 3, 4, 5, 6, 7, 8, 9. Is it making 0? 1, 2, 3, 4, 5, 6. Okay, tell me when it's at 0, not just about. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, you good? Do you need a white while I'm here? Okay, good. Sure, not a problem. You good? Okay. Oh, you need me? Not a problem. I'm here for you. You're welcome. Thank you.
I sent out the media advisory. I know it said 11. In fact, I sent it out twice because there was an issue with the well, there's always an issue with the Alan can attest to that. The media RSVP link.
Did it kick you out again?
Yeah.
Okay, here's the thing. Who wants for me to like RSVP and know how to do it?
Just the email. Yeah, if you just figure out how to do it, send it like Christina. I wonder if Christina wants her to ask a question.
Christina, the only
Because Christina called me that morning to make sure she gets like the RSVP email.
Audio check, 1, 2, 3, 4. 1, 2, 3, 4. Audio check, 1, 2, 3, 4. Cynthia? Hello, hello, hello.
They're coming in clear on my end.
Audio check, 1, 2. You good? Okay.
Luke Barr, I think it's
Luke Barr's on. Yep, I saw him. Molly sent it to me. Normally I like to have Mark or I always present. Like I always did it, so I can see this there. But I mean, I'll see it on my Teams. That's okay. Usually like during it, I'll start trying to organize the queue while everyone's getting out. And I you will just leave us connected with the reporter, so our mic will be hot. That would be helpful.
Yeah, so you want me to join us in at the 2-minute warning?
Yes, but
Or join us in for...
I'll message you before that, so not yet.
Okay.
Just want to make that aware to you.
Yeah, no problem. And then just to inform you, once I do join us in, you'll just hear hold music for a moment. And then once I turn off that hold music, that means you're going to be live with your audience at that point.
Great, thank you so much.
Yeah, absolutely.
Hey y'all, we're about to go live, so if you can make sure to silence your cell phones and please stop talking. If you absolutely have to have a conversation, please step out into the hall, and not just out into the hall, but out into the hall, because we can still hear you right outside the door. All right, I'm going to give you 2 minute warning. You can go ahead and join us in.
All right, I'll join us in now, and I'll turn off the music. Just 1 moment.
Thank you for calling in to the DOJ press conference today. We will begin the speaking order with U.S. Deputy Attorney General Jeffrey Rosen, followed by U.S. Attorney Christina Nolan of the District of Vermont, First Assistant U.S. Attorney Rachel Hoenig of the District of New Jersey, and Acting Assistant Attorney General Jeffrey B. Clark. U.S. Attorney Stephen Cox of the Eastern District of Texas will also be available for questions afterwards. There will be a background following this immediately after the formal press conference, so please, if you call in, stay around, we'll get through your questions. This is the formal 2-minute warning. Thank you.
Okay, well, good morning. I'm Jeff Rosen, and I'm very pleased to be joined today by Vermont's United States Attorney, Christina Nolan, by New Jersey's First Assistant U.S. Attorney, Rachel Hoenig, our Acting Assistant Attorney General for the Civil Division, Jeff Clark, and the Eastern District of Texas U.S. Attorney, Steve Cox. This morning, subject to court approval, the Department of Justice is announcing a global resolution of our criminal and civil investigations into the opioid manufacturer Purdue Pharma, as well as a civil resolution with members of the Sackler family who comprise shareholders of the company. Before we address the specific terms, I want to provide some context of how today's announcement fits into DOJ's wider efforts to address the opioids crisis. DOJ obviously has many longstanding and ongoing drug enforcement activities. But during this administration, we have augmented those with a series of new initiatives targeted at both illicit opioids, like heroin or synthetic fentanyl, and we've targeted the diversion and abuse of prescription opioids as well. These are shown on the chart we have today. This one over here, where we show J-code and Operation SOS on the illicit side of things, and we show the PIL task force, the Prescription and Interdiction Litigation Task Force, ARPO, OFIDU, and healthcare fraud strike forces, all on the prescription side. And by all of these efforts, we have targeted unlawful activity involving opioids at every level of the supply chains. There's very different supply chains on the illicit side and on the prescription side. On the prescription side, this means unlawful actions by manufacturers, distributors, pharmacy dispensers, or physician prescribers, for example. So today's announcement involves one of the most important participants in the supply chain of prescription opioids at the manufacturer level, and a resolution which, if approved by the court, will redress past wrongs and will also provide extraordinary new resources for the treatment and care of those affected by opioids addiction. The global settlement announced today involves the company pleading guilty to 3 felony counts for defrauding the United States and violating the anti-kickback statute from 2009 to 2017. In addition to the company having agreed to plead guilty to these 3 felony counts, the company has agreed to a $3.544 billion criminal fine and a $2 billion criminal forfeiture amount. Further, on top of those, to resolve its civil liability, Purdue Pharma has agreed to $2.8 billion in damages to the United States. Now, the company's in bankruptcy, so the corporate resolution is subject to the bankruptcy court's approval. If it's approved, this will be a corporate settlement in total of more than $8.3 billion. Additionally, members of the Sackler family have agreed to pay $225 million in a civil settlement that will provide civil releases only. It's also important to note that this resolution does not prohibit future criminal or civil penalties against Purdue Pharma's executives or employees. Now, this resolution must be understood against 2 larger contexts. First, the company's bankruptcy, and second, as I've referenced, the Department of Justice's overarching work addressing the opioids crisis. We'll take the first one first, the bankruptcy. The company's bankruptcy in the Southern District of New York involves many creditors, from some private creditors to federal, state government, and local creditors. In general, the creditors are aiming to ensure that nearly all of the proceeds of the bankruptcy go to opioid abatement programs, and the Department of Justice generally supports that goal. Towards that end, a key piece of today's resolution is based on the future of the company that was Purdue Pharma. The agreed resolution, if approved by the court, will require that the company be dissolved and no longer exist in its present form. It would require that the Sacklers must relinquish all ownership and control of the company or of any of its successors, and the company's assets would be transferred to a new public benefit company, or PBC, owned by a trust for the benefit of the American public. The PBC would be charged with providing its medicines in a manner as safe and possible, without diversions, while providing millions of doses of medicines to treat opioids addiction and to reverse overdoses, and otherwise taking into account long-term public health interests. And again, to be clear, the Sackler family will have no role in creating or controlling the new PBC. If the bankruptcy court approves this, the department will credit the company for the value conferred through the PBC against the criminal forfeiture amount, except for $225 million that will be paid to the United States on the bankruptcy effective date. The criminal fines and civil damages would not be affected by this. This global resolution builds on the department's other recent opioid successes. Just as the department prosecutes illicit drug traffickers, the department's been committed to doing the same with respect to the abuse and diversion of prescription opioids. We've prosecuted medical professionals who've contributed to overdose deaths, or run pill mills, or defrauded the government's health care programs. We've prosecuted opioid distributors, including McKesson, Miami Lucan, and Rochester Drug Cooperative. We've reached substantial settlement resolutions with other manufacturers, such as RB Group and Indivior, as one example, which was, if I recall, in the neighborhood of $2 billion, as well as another manufacturer, Insys. These are all examples of the department's unwavering commitment to turn the tide of the opioid crisis that's ravaged the country. Today's announcement focuses on the problems from wrongful activities in the prescription opioids realm, so let me note that our efforts there appear to be making a difference. The CDC reports that since 2017, prescription opioid overdose deaths have decreased by more than 18% in the first 2 years. And there has been a 47% decline in prescription opioids being dispensed. But we will continue all of our efforts, including building on the record of more than 8,000 opioids prosecutions in 2019. And not only through enforcement. For example, the Department's Office of Justice Programs awarded grants totaling more than $341 million to help fight the addiction crisis looming over the United States. Let me also say today's announcement is very much a success story in the close coordination between the U.S. Attorney's offices in New Jersey, the U.S. Attorney's Office in Vermont, the Civil Division's Consumer Protection Branch and its Civil Fraud Section, and I also want to thank the important contributions of law enforcement, including the FBI, the DEA, and the Health and Human Services Office of Inspector General, all of whom would normally be here with us, but because of the pandemic, we've limited the number of people on the stage today. So I want to thank this entire team for their relentless work in bringing about this investigation and bringing it to a successful resolution. Today's announcement is also particularly timely, given that October is National Substance Abuse Prevention Month, and just a few days from now, on October 24th, is DEA's National Prescription Drug Take Back Day, which allows for a safe, convenient, and responsible means for disposing of unneeded prescription drugs that are sitting in medicine cabinets at homes. Keeping the American people safe is the department's highest priority. And as today's announcement reaffirms, the department will not relent in our efforts to combat the opioids problem. At this point, my colleagues will tell you more about these cases and about the specific terms of the global resolution. So let me start with my colleague, the U.S. Attorney from Vermont, Christina Nolan.
Good morning, everyone. I'm Christina Nolan, the U.S. Attorney for Vermont. I want to begin by thanking my colleagues at Maine Justice, Director Gus Eiler of the Consumer Protection Branch and his team, as well as everyone on the civil team that was involved in this case, led by Assistant Attorney General Jeffrey Clark. I want to thank First Assistant U.S. Attorney Rachel Hoenig of the U.S. Attorney's Office in New Jersey and her team. So many of them are here today. It's great to see them. And of course, I want to thank you, Deputy Attorney General. I want to thank everybody involved in this case for their partnership, their support, and their leadership. Purdue's execution of a plea agreement and civil settlement agreement will resolve its criminal and civil liability in connection with an illegal kickback it paid to Practice Fusion, which is an electronic medical records vendor, and we call that EMR vendor sometimes. My office conducted the investigation into Purdue's liability under the federal anti-kickback statute for its kickback to Practice Fusion, and Purdue's expected guilty plea for that conduct will mark the first of its kind in the history of the country, a milestone in our efforts to combat corruption in the healthcare industry and the opioid crisis in America. In 2015, Purdue negotiated with Practice Fusion to create a series of alerts in the Practice Fusion EMR software designed to influence doctors to prescribe more of Purdue's very addictive extended-release opioids, or EROs, such as OxyContin. And many of those ensuing prescriptions were paid for by federal healthcare programs. The Purdue-sponsored Practice Fusion software accomplished the goal of increasing ERO prescriptions through software prompts that influenced doctors to focus more on pain and suggested that they select EROs as treatment when it was not medically necessary or appropriate to do so. In September 2015, Purdue agreed to pay Practice Fusion nearly $1 million in exchange for embedding the alerts in the EMR software for 1 year. Purdue recognized the power of EMR alerts to influence prescribing decisions. Indeed, in an internal document in early 2016, Purdue described the EMR alerts as, quote, a marketing tactic that would drive ERO demand and grow ERO prescriptions. Purdue's marketing employees helped Practice Fusion design the alerts. The kickback effectively put Purdue's marketing department in the exam room with a thumb on the scale at precisely the moment doctors were making critical decisions about patient health. The Purdue-financed EMR alerts triggered in exam rooms across the country from July 2016 through April 2019. They were discontinued only when my office discovered the crime and raised concerns with Practice Fusion. But unfortunately, that was not until after the alerts fired more than 230 million times. The unlawful dangerous scheme put profits over people by seeking to increase scripts for addictive EROs even when they were not medically appropriate and at the height of the US opioid crisis. A time when in Vermont, where I'm from, and across the country, people were suffering under opioid addictions that sometimes ended in death, and so many of those addiction stories began with OxyContin. It is wrong, and we hope that Purdue's guilty plea will send a message that the Department of Justice will not allow big pharma and big tech to engage in illegal conduct that corrupts the doctor-patient relationship. Lastly, and briefly, I want to recognize those who did the hard, groundbreaking work in the Vermont investigation. The U.S. Attorney's Office in Vermont is small. It's one of the smallest in the country. We're a small state, but we punch above our weight. And I'd like to thank the Vermont team, led by Assistant U.S. Attorneys Owen Foster and Michael Drescher. They are two of the finest Assistant U.S. Attorneys in the country. And I'd also like to thank our talented investigator, healthcare fraud investigator, George Tabo. Lastly, thanks to our outstanding federal law enforcement partners, the FBI and Health and Human Services Office of the Inspector General. They did tremendous work on behalf of the public, and I'm proud of and thankful for their partnership. Thank you.
Good morning. My name is Rachel Hoenig. I am the first Assistant U.S. Attorney for the District of New Jersey, and I am the Attorney for the United States in that district for this matter. My office and the Consumer Protection Branch of the Civil Division of the Department of Justice led the the criminal investigation into Purdue for its conduct in marketing and selling opioids to healthcare providers who it had good reason to believe were diverting them to abusers. My office also worked jointly on the civil investigation conducted by the fraud section of the Civil Division, and AAG Clark will address that component of the case a little bit later in his remarks. Our criminal investigation in this case revealed that Purdue placed profits over public safety in three major respects. First, Purdue marketed and sold addictive and dangerous opioids, including OxyContin, to healthcare providers that it had good reason to believe were diverting them. And it made misrepresentations to the DEA about the effectiveness of its program to detect and prevent such diversion. Second, Purdue passed off these sales to the DEA as legitimate, enabling Purdue to obtain a higher quota from the DEA for the amount of its medications it was legally permitted to market and sell. Finally, Purdue used its speaker program to pay kickbacks to providers to incentivize them to prescribe even more of Purdue's products. When it pleads guilty to and is sentenced for this conduct, Purdue will accept responsibility for this behavior. I want to be clear, this resolution does not provide anybody with a pass on the criminal side. Purdue is pleading guilty to 3 felonies and faces a substantial forfeiture judgment and criminal fine. This resolution does not provide a criminal release or an agreement not to prosecute for any individual, and our criminal investigation regarding individuals is ongoing. Finally, I want to express my office's gratitude for the extraordinary cooperation in this case among several different components of the Department of Justice and, of course, our agency partners. My office has been working hand in hand in this case with Director Eiler's team at Consumer Protection, consisting of Gabe Scanapico, Kara Traster, Marianne McGuire, Rachel Barron, Michael Collier, and Hillary Perkins. And we're very thankful for their partnership, and particularly that of their director, Gus Eiler. U.S. Attorney Nolan's team, the Civil Division team, and our colleagues in the Deputy Attorney General's office, including Associate Deputy Attorney General Amanda Liscombe, have been tremendous partners to us throughout this process as well. And U.S. Attorney Steve Cox's leadership and guidance in this matter was invaluable. Our agency partners, as U.S. Attorney Nolan mentioned, have been with us every step of the way, and that includes the FBI, HHS, HHS-OIG, and the DEA. And we expect that they will continue to do so as the investigation continues. I thank them for their partnership and their support. And finally, I want to recognize my own team, who worked incredibly hard to bring this resolution to this stage. On the criminal side, that includes Deputy Chief of the Criminal Division, Nicholas Grippo, Opioids Chief Melissa Wangenheim, and Assistant U.S. Attorneys Steve Furketic and Sean Sherman. On the civil side, it includes our healthcare fraud Chief Lee Cortez and Assistant U.S. Attorneys Nicole Mastropieri and Mariu Cedeno. This was a huge team effort across the board, and I want to thank everyone and congratulate them for their hard work.
Thanks very much.
Good morning. I'm Jeff Clark. I'm the head of the Civil Division. And first, I wanted to start out by thanking the Deputy Attorney General for his leadership and my U.S. Attorney counterparts and partners for tremendous team effort. I want, beyond that, to begin by echoing the Deputy Attorney General's thanks for the tremendous work that went into this case. Today's accomplishment is a major milestone in the Civil Division's efforts to combat the opioid crisis by holding accountable those who fueled it. As we've seen time and again, the opioid epidemic is exacerbated when companies and individuals involved in our healthcare system put profit above the well-being of patients. The Civil Division remains committed to using all of the tools at its disposal to investigate and prosecute such crimes. We have both civil authority and criminal authority in our division. These tools include not only pursuing the type of criminal violations discussed by the Deputy Attorney General and my colleagues from the U.S. Attorney's offices, but also civil remedies, which is what I'm here to focus on, including under the False Claims Act, designed to protect taxpayer-funded healthcare programs from fraud and abuse. The civil resolution announced today with Purdue resolves allegations that the company violated the False Claims Act by engaging in an aggressive marketing campaign that caused providers to prescribe opioids for medically unnecessary uses that were paid for by the federal health care programs and system. This civil resolution that we announced today with the United States provides the United States with a general unsecured bankruptcy claim in the amount of $2.8 billion as part of the overall $8.3 billion resolution announced today with Purdue. Separately, as has been noted, the department has reached a $225 million civil settlement with the Sackler family, which owns Purdue through various trusts, to resolve their role in Purdue's marketing activities. Today's resolution should serve as a reminder to the pharmaceutical industry that the department is very serious about its commitment to combating healthcare fraud, particularly as it relates to the misuse and abuse of opioids. The department will continue to work closely with its federal, state, and local partners to safeguard the integrity of government healthcare programs and to combat the ongoing opioid crisis. Finally, I want to thank all of the public servants, attorneys, investigators, and support staff from the Civil Division's Commercial Litigation Branch and Consumer Protection Branch, the United States Attorney's offices on the dais here today, the Federal Bureau of Investigation, the Department of Health and Human Services, the Defense Health Agency, and the Office of Personnel Management, who worked tirelessly on these matters to achieve these tremendous results. And I'd like to give a special shout out to the efforts of my two deputies, Dan Fife and Michael Granston. Thank you.
Okay, well, at this juncture, what we do is open it up for questions, and we'll call on folks as needed, but I'll try to mediate here, so whenever the questions are ready.
And we will now begin the question and answer session. To ask a question, you may press star then 1 on your touch-tone phone. If you're using a speakerphone, please pick up your handset before pressing the keys. To withdraw your question, please press star then 2. We kindly ask that you please limit yourself to 1 question. And at this time, we'll pause momentarily to assemble the roster. And our first question today will come from Susanna Leah with Politico. Please go ahead.
Thank you. I have a 2-part question. The first one is just timing-wise, when did DOJ start this probe into Purdue? And maybe you could describe kind of the just the timing of that. And then do you have any response? I know last week 25 state attorneys general rejected the idea of a public benefit company with some criticism of taxpayers being a part of that. So could you address those criticisms? Thanks.
Yeah, there's 2 parts there. I'll take the public benefit company in just a second, but in terms of when the investigation started, I'll invite others, but it's been going on for several years. Rachel, you want to take that one first, or Christina? Sure, come on up.
Thank you. So for the Vermont investigation began in August of 2018. As I mentioned, the unlawful alerts that were the result of the kickback were removed in the spring of 2019, and we had an agreement in principle with Practice Fusion by August of 2019 with the announcement of that settlement in January of 2020. Thank you.
And on the New Jersey and consumer protection side, our criminal investigation as well as the civil investigation that we conducted jointly with the Civil Division has been ongoing for several years, dating back to at least 2017.
So with regards to the investigation, obviously it's gone on for several years and started coming to a conclusion this year. There was a process in the bankruptcy court had set a schedule for proof of claims originally for July, and then I think it was around the 1st of August. That had a significant impact on some of the timing of the negotiation process. On the other half of the question, there's some differences of opinions among state attorney generals, as I understand it, some who are very supportive and others who are not. I think our judgment was that to have the resources of the company be put towards the abatement and treatment of opioids and towards the development of new treatments, medically assisted treatments, and of pharmaceuticals that could help reverse the effects of overdoses was a very desirable outcome, that this was a resolution that would divest the existing shareholders, which are Sackler family members, of any holdings or involvement, and ensure that these resources would be put to positive uses, if approved by the court, would be a positive development. It was also our judgment on this that while prescription opioids can be abused, diverted, misused in very harmful ways, it's a prescription pharmaceutical that does have some positive uses, and that maintaining the supply of those is itself something that could be beneficial. So we have entered into this global resolution supportive of the concept of a PBC, and that will ultimately be up to the court in the Southern District of New York to assess. Next question.
And our next question will come from Luke Barr with ABC News. Please go ahead.
Hi, Mr. Deputy Attorney General. I appreciate taking the question today. I have a question sort of about the criminal aspect of it. You know, the Sackler family is, in 2016, has been estimated at $13 billion. And you know, you said that you have a fine of $225 million today. If there are criminal charges against the Sackler family, will you seek more money in fines as well as any criminal remedy?
So let me say first, I think that the resolution that was achieved on the civil side with the shareholders and the global resolution with the company are very favorable, not just for the United States, but for other creditors, including the state governments and other local governments and entities that are involved. And part of the thing to keep in mind, as I alluded to in the bankruptcy context, is there are a number of other participants. And one of the things we wanted to do was ensure that with regard to some of these other claims, resources would also be made available for treatment and abatement kinds of efforts. And so I think it's important to keep in mind that there are other participants also negotiating with both the company and the shareholders here, so that the ultimate resolution in a bankruptcy won't just be the United States claims that we've outlined here, but additional resources. And we are generally supportive of resources being applied, as I said, to opioids resolution or treatments and abatements. So I don't want to get into hypotheticals as to what could happen next with regard to the United States. I think I want to stay with the fact that we see this resolution to date, both the company resolution and the civil resolution with the shareholders, as a positive development for Americans generally and for creditors in the bankruptcy widely, including the United States, but not only the United States. Next question.
And our next question will come from Kadim Shuber with Financial Times. Please go ahead.
Hi there. Thank you for doing the call. This is a question for Deputy Attorney General Rosen. You talked about how the opioid crisis that Purdue drove, it was ravaging this country. The Sackler family profited from that. They took $10 billion out of the company over the decade until 2018. You are requiring them to pay $225 million. That's a little over 2% of that $10 billion they took out of the company. Why have you let them keep all that money?
So I think that's not the right way to look at this, because it is Purdue Pharma, the company, that was charged both criminally and civilly here, and the shareholders are a part of the resolution. I think it's wrong to say that anybody was, quote, allowed to keep things. The resolution here is very significant. It involves, for the company, 3 felony guilty pleas. For both the company and the shareholders, it involves very sizable amounts of money. And it is important to remember that the issues involved are the abuse, misuse, diversion of opioids, but there are legitimate uses of opioids. So we have to separate the misconduct from what I'll call ordinary business. And the resolution that's achieved here today is very substantial, very significant. And with regard to the shareholders, and the Sackler shareholders is what I'm referencing, in terms of what they, quote, got to keep, they lost control and ownership of a company that was worth very significant amounts of money. They will have no future involvement with that company if the bankruptcy court approves this resolution. Instead of being the owners of a major pharmaceutical company, they will have no stake in that company. Instead, it will be a public benefits company with no continuing participation or involvement by them. So I think some of the premises may be an erroneous way to look about it, because both the company and the shareholders are paying a very steep price for what occurred here. Next question.
And our next question will come from Jeff Bailey with Bloomberg News. Please go ahead.
Good morning. I wanted to ask Deputy AG Rosen why you guys decided not to pursue criminal charges against any members of the family. The civil settlement is just that, a civil settlement. This was, in part, a criminal investigation. So I guess the question is, why did you guys not decide to proceed with, criminal prosecution of some of the members of the Sackler family that are, involved deeply in the operations of the company?
So I'm going to stick to the terms of the resolution here, which are civil and do not include releases of any other kinds of liability, and say that the resolution we've reached is the resolution we've disclosed today. It is neither predictive of or preclusive of other or future or different resolutions on things that weren't covered by today. Jeff Clark will...
Yeah, I thought that I would just amplify on the civil side that, as the Deputy Attorney General said, the penalty here for the Sacklers in conjunction with this particular civil violative conduct that's alleged is steep. We're talking basically about running an illegal marketing scheme, and in light of that illegal marketing scheme, which was called Evolve to Excellence, or E2E, they had that fancy name for it, but it was chicanery nonetheless. This is a very substantial penalty for that conduct. And, the Attorney General obviously has made the points about the fact that, this is not something that's preclusive of other potential remedies.
We in all cases proceed on the basis of the facts as the investigation reveals them and the proper application of the law. And that's the basis for how we proceed. Next question.
And our next question will come from Hannah Kuchler with the Financial Times. Please go ahead.
Hi there. Thanks for taking the question. I just wanted to follow up on the $10 billion that the Sackler family has tried to take out of this company. I wanted to know, did you ever try to pursue that money?
Well, I'm going to go back to what I've said before, because two things. In the bankruptcy proceeding, there are multiple creditors in addition to the United States, and there have been other negotiations that proceeded beginning in the multi-district litigation in Ohio. So in terms of the resources of either the company or the shareholders of the company, there are multiple different types of claims going on, and they are all part of the larger negotiation. The other thing I would say, really building off, I think, the prior question and answer, is the way the law works is we have to deal with specific acts of wrongdoing that we've investigated and determined what the exposure and liability is for that. There is no law that says if you've done something wrong, we should just simply strip somebody of all their assets in existence. That's not how it works. It has to be that we are looking at specific acts of wrongdoing, civilly or criminally, and then having a proportionate response to what the role of those acts is. And it's in that context that we've reached the resolutions that we have. And I think by any measure, a resolution of the company that involves criminal and civil resolutions in excess of $8 billion, that involves the felony guilty pleas, that involves contributions, financial contributions from the shareholders on the civil side, and that involves divesting the shareholders of any ownership or future involvement with the company that they had owned for many years, those are extremely significant and serious measures, but they are part of this resolution as proposed to the court. Next question.
And sir, at this time, I'm seeing no further questions.
Okay, well then we'll thank everybody, and I understand that some of our folks here will be available for some additional background to the extent that's helpful. Thanks very much.
And ladies and gentlemen, this concludes the formal press conference, but we remind participants to please stay on the line for the backgrounder. And once again, if you would like to enter the queue, we just kindly ask that you please press star then 1. If you would like to remove yourself from queue, you may press star then 2.